higher education place of employment address in accordance with Division A to C of this section by the date required for verification set forth in Division D of this section. The most serious sexual word of domestic child victim reporting presents the basis of the registration knows that the country results in community possess education or address verification requirement to violate the prohibition of unlawful sexual conduct with a minor or felony of fourth degree. Hamilton County, Ohio, Court of Common Pleas in case number D12-01659 on June 7, 2012. May we deliver it as a back to the back to that certificate.
Yes.
Anything down on the facts of the plea, Mr. Kevin?
No, Your Honor.
Mr. Williams, did you hear the facts that were relayed to you by the prosecutor?
Yes.
Yes, that's true now.
Yes.
Do you understand the charge against you?
Yes.
Are you making this plea of your own free will?
Yes.
When they threats to you other than the prosecuting charge against you in order to get you to plea? Have any promises of any kind to myself or anyone who made you in order to get you to plea? Understand, so this being a felony of the fourth degree, the maximum penalty, sir, is anywhere from 6 months to 18 months with the Ohio Department of Corrections with a maximum fine of $5,000. I also need to advise you that if I was to send you to prison upon your release from prison, you could be placed in what is called post-release control for up to 3 years. Do you understand that?
Yes.
Just to finish that thought for Mr. Williams. If I was to send you to prison, and if upon your release from prison you were placed on post-release control by the Adult Parole Authority, you then violated any conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of the original sentence. Do you understand that?
Yes.
Thank you, sir. Since this is a felony of the fourth degree, community control, which is the old probation possibility, I understand you can be placed on community control for up to 5 years instead of going to prison. And what I've been told, this is where it gets important for you. If I place you on community control and you violate any of the conditions of the community control, then you come back in front of me for a more restrictive sentence, which could include imposition of prison time we talked about. Do you understand that?
Yes.
Thank you, sir. I also need to advise you that if I was to assess court costs, and you fail to pay the court costs, the court could order you to perform community service instead of paying court costs. Do you understand that?
Yes.
Thank you, sir. And how old are you, Mr. Williams?
28.
How far did you go to school, sir?
12th grade.
So you can read and write okay?
Yeah.
Thank you, sir. So I'm holding in my hand a 3-page document which stands an entry withdrawn pleaded not guilty and then pleaded guilty. Did you read this document over, sir?
Yes, sir.
Do you understand what's on it?
Yes.
Do you have any questions, sir, about anything that's on this document?
No, sir.
I'm sure Mr. McEvely wrote it with you, is that correct?
Yes, sir.
Do you have any questions of him regarding anything on this document?
Yes, sir.
Thank you, sir. So on the third page, the line that says signature of defendant, above that line there is a signature. Is that in fact yours?
Yes, sir.
Would you put that on there of your own free will?
Yes, sir.
Anybody make the sign?
No, sir.
So when you plead guilty, you make a complete admission of your guilt.
Yes, sir.
So now the judge can find you guilty as soon as I accept your plea.
Yes, sir.
And after accepting your plea and upon finding you guilty, I can proceed to sentence you with the limits allowed by law that I've already described to you.
Yes, sir.
Are you present right now, sir, on any type of probation, parole, post-release control, anything like that? Good. So when you plead guilty, you do give up some of your important constitutional rights, and then you go through this before you can ask the judge. You understand that by entering a plea of guilty, you give up the right to a jury trial as well as to a trial of the court.
Yes, sir.
You understand that by pleading, you give up your right to confront witnesses against you. You're an open court trial and have been cross-examined by your attorney. You understand that by pleading, you give up the right to have witnesses if you need to come to court to testify for you.
Yes, sir.
You understand that by pleading, you give up your right to make the state prove your guilt beyond the reasonable doubt.
Yes, sir.
Finally, Mr. Williams, regardless of those rights, sir, you understand that by pleading, you give up your right to a trial, either in the court or a jury as you would choose, for which you could not be made to testify against yourself.
Yes, sir.
Thank you, sir. So have you taken any type of medication or drug with or without a prescription in the last 24 hours?
No, sir.
Have you taken any alcohol in the last 24 hours?
No, sir.
You understand conviction for this offense requires you by law to provide the law enforcement a DNA sample.
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Finally, Mr. Williams, can you talk to Mr. McEvely about this case? Talk to your attorney about it?
Yes, sir.
Can you talk to that your client? Can you talk to you about it?
Yes, sir.
I'm sure, sir, on your behalf, to talk to myself as well as the prosecutor. I've known Mr. McEvely for a long, long time. He's a very good attorney, but I still need to ask you, are you satisfied with the work that your attorney has done for you?
Yes, sir.
Good. You still wish to enter plea then, sir, to the charge of periodic verification of current address violation felony of the fourth degree.
Yes, sir.
What is your plea, sir?
Guilty. Sorry. Long.
Is that correct, Counselor?
Yes, and we did discuss both of those beforehand, Your Honor. Yes.
Based on all that's transpired before me, I find that Mr. Williams is knowing, intelligent, and voluntarily entered the plea. The court accepts the plea, makes a finding of guilty, violation of periodic verification of current address felony of the fourth degree. You are requesting a pre-sentence investigation, is that correct?
Yes, Judge, and we've got a date on the 21st of September.
On the 21st, okay. What that means is, Mr. Williams, sir, if you can remain under the same bond, please make sure you cooperate with probation. And above all else, sir, make sure you're back on the 21st. We'll take care of this matter at that time.
Yes, sir. Thank you.
Thank you, Mr. McCaffrey.
Thank you, Your Honor.
Thank you, Mr. Brewer. I think we're all set. Give me just 1 second. You can go ahead and bring them over. Very nice. So you don't need to- Ohio versus Anthony Kirkman, case number B090169. Before I do anything else, let the record reflect that the council and myself had a conference very briefly before I came out here today, and it was of procedural nature as to how this was going to go today. Nothing of substance was discussed in compliance with the law. At this point, and I know I told Deputy Ruhlman I would have him up, but thank you for checking, sir. I'll get him up here very shortly. But the defendant is represented by Mr. Tim Fisher, as well as Mr. Richard Wendell. The state is represented by Joseph Peters, Mark Pittmeyer, and Ray Gibson. We are here for sentencing by the court pursuant to a jury returning a verdict finding for the imposition of the death penalty. My sentencing opinion, which is required by law, will be filed with the Ohio Supreme Court shortly after this procedure. Before I do anything further, I am going to take a little time here to extend my sincere gratitude to some of those who helped make this trial comply with the law and who helped show our community that this justice system does work. Many contributed, but I must mention the following. First of all, my staff, Chris Glean, my bailiff, Mary Ann Stout, Anne Marie Stowers, my court reporter, and Andy Crown. Did a lot of work on this thing, a lot of good work, and I appreciate it from all of you. I also want to thank the Sheriff's Department and Court Service Division, who just did an absolutely outstanding job. And having to sit through what you all sat through, many aspects of security that you took care of for me, I surely appreciate that. I also want to thank Brad Seitz, the jury commissioner. He put up with a lot. A lot of people went through there. He treated them all very nice. He did a great job. Cheryl Best, the bailiff for Judge Steve Martin, helped out a lot, and I appreciate that. And I also want to thank the news media and the media. You certainly followed the rules, which is appreciated. Your cooperation and professionalism during the entire time was much appreciated, and I think it worked well for everybody. I also want to thank and commend for their dedication to public service and their professionalism, the Cincinnati police officers involved in all these cases, but especially Detective Keith Witherall and Detective Bill Gilbert. Outstanding job by everybody. Those who, without question, pursue justice with dedication and skill, and they are deep connected. I also want to thank the defense attorneys. I mean that. Mr. Fisher and Mr. Wendell put in a tremendous amount of hard work on this case. Zealously and professionally representing Mr. Kirkland. I appreciate that. I also need to thank the prosecutor in this case, Mr. Joseph Peters, Mr. Mark Pittmeyer, and Mr. Rick Gibson, did an outstanding job presenting this case and seeking justice on behalf of the people of the state of Ohio. I appreciate the job done and the contribution to our justice system. And finally, but obviously to me at least, the most important thanks and commendations goes to the jury. Many of them here, and that's fine, but anybody that watched this case, and I'm not making any reference to the verdict, obviously, I'll do that, I'm not. I want to thank them and commend them. That was a very, very, very tough, emotional, ruling at times case. And every one of those jurors fulfilled every bit of their call to civic duty. They are good people, good people who serve the justice system in our community well. It's jurors like those who participate in this particular case that make our justice system the best that it is, the best in the world, and they help to keep America great. My wholehearted commendation to them. So with that, we'll go ahead and proceed with the sentencing of Mr. Anthony Kirkland. If you will all please step up. Anything by way of mitigation, Mr. Wendell, Mr. Fisher?
Your Honor, thank you. On behalf of Mr. Kirkland. Your Honor, I know the court has received a copy and has reviewed our memorandum of law, and in support of a sentence of life imprisonment without the possibility of parole. Judge, we believe that there are compelling reasons why a life sentence, and specifically a life sentence without the possibility of parole, is appropriate in this matter. Judge, we would submit that Mr. Kirkland's history, character, and background weigh strongly in favor of a life sentence. You heard testimony regarding the severe childhood abuse that he was subjected to and the toxic developmental environment in which he was raised. You had heard testimony regarding the physical abuse the emotional neglect, the physical neglect and psychological abuse, domestic violence, sexual abuse, and mental illness in a household member, substance abuse that he grew up with, and substance abuse in a household member, and ultimately the separation from parent or parents. Judge, you heard testimony that his brain structures were actually different. He evolved differently. His brain became, for lack of a better term, just not normal anymore. Judge, he noted, Dr. Wu noted that his brain findings were associated with physical, sexual, and emotional abuse. And in light of those facts, we believe his background, history, and character weigh strongly in favor of a sentence of life. Judge, additionally, we believe that you heard testimony and the factor that at the time of committing the offenses, Mr. Kirkland, because of a mental disease or defect, lacked substantial capacity to conform his conduct to the requirements of the law. We believe that this strongly favors a life sentence. Judge, you heard the medical findings on PET scan, MRI, diffuse tensor imaging, and MRI quantitative diagnostics, that his brain showed consistencies with CTE, chronic traumatic encephalopathy. He had a documented bicycle accident in 2004, as well as other traumatic brain injuries. You heard statements and testimony that he was a completely different person at the time after such traumatic injuries. Dr. Van Ays, you heard testimony that he suffered from post-traumatic stress disorder with dissociation, which caused his brain to judge non-threat as true threat, and that was relative to the homicide victims that we're here for today. That set off his flight or fight response, and we believe that that weighs strongly in favor of the sentence of life. Judge, additionally, and I think these can be referenced in a number of different mitigating factors, but in summary, his history of mental health problems, the fact that he sought repeated medical interventions, especially in the period of time right before February of 2009. On at least 6 occasions, he sought medical help and attention for his mental health issues. He had psychiatric emergency admissions for suicidal ideation, depression, mood swings, dizziness, blackouts, syncope. All of these things weigh heavily in his favor, and the fact that he voluntarily was seeking treatment for it is important, and we believe that is a significant consideration for you. Judge, additionally, his acceptance of responsibility, his apologies, his remorse, I would submit to you that that is a very important factor and should weigh heavily in favor of life. Judge, he accepted responsibility for the homicides, and you heard Dr. Van Ays and Mr. Kirkland indicate he can't properly or effectively give a reason for what happened. But it did happen, and he has accepted that. He's confused why he would kill people that did not deserve it. And Judge, we believe that his request for mercy, his request that his life be spared, while maybe not specifically a mitigating factor, is something that can be considered by the court. Judge, you heard history of drug and alcohol abuse throughout the course of his life. It started from a very early age, an age when he should be attended to by loving, caring, welcoming adults, and instead was introduced to drugs and alcohol. That's a factor that you could consider. And finally, Judge, and very significantly, and something that we believe is entitled to significant weight, is his confession and cooperation with law enforcement. Specifically, Judge, not only that the homicides that we're here for with the specifications were solved, but also that the information that he voluntarily gave regarding the body of Kimya Rollison enabled her family to learn what happened, to learn what the truth about what happened, and ultimately that she was buried with her mother. Judge, we believe that all of those are factors that weigh strongly in favor of a decision of life without the possibility of parole instead of death. We believe that those are important factors and would weigh strongly in his favor. Judge, I know Mr. Kutcher would like to address the issue relative to costs as well. Thank you.
As the court well knows, Mr. Kirkland is indigent. He's had the benefit of appointed counsel in cost for depositions. We've gone to the West Coast twice, been to Columbus, Ohio, been an extensive amount of costs. The court does have the discretion to waive those costs, and I would ask the court to consider doing that.
Mr. Kirkland, is there anything you want to say, sir?
Well, along the lines of what Mr. Kutcher was saying, in good faith, I have been writing the Hamilton County Clerk of Court's office, room 315, inmates and prisoner accounts, to offer a $3 a month consistent payment on the $9,000 current court costs that I had. I get $16 a month. They wanted $25, and they didn't want to take it. So if I'm trying to make forth a payment and I'm not being able to, the court wants us to have somebody on the outside to bring them $25 a month. I don't have that. I get 16. And they want it to be mailed in. It's either this or nothing. So I'm asking if you decide not to waive the court costs, if you would appoint me some legal representation to address this issue, because I'm trying to put payment toward a debt to satisfy, and I'm not being allowed to even have commercials on television when people who are like $10,000, $15,000, $20,000 in debt, that they're paying off debts at a fraction of the cost. So it's basically the issue of the court costs. I don't know how many tens of thousands has been acquired from these last 2 years proceedings on top of that. So that's all I'm requesting. Or for you to make arrangements for the court to allow me to pay the $3 as a monthly consistent to pay down the debt.
Is there anything else you would like to tell the judge?
Basically, everything was said in my unsworn statement, and I stand by that. That's basically, if that's what we're getting at.
Thank you, Your Honor.
Judge, just with reference to that request, it's obviously an attempt to keep money on the books for him in prison, so his commissary account is still able to be spent, and we're opposed to that. I know he never has any intention of actually paying this debt, but we don't want him to get money put on the books so he can spend money freely in prison and ignore his debt, so we'd be opposed to that. Judge, the only other thing we'd say, and you already mentioned it before, take the opportunity really to recognize the work of the Cincinnati Police Department on this case. It began with Canine Officer Jennifer Ernst, who, had she not taken upon herself that night to go to try to find Esme Kenny, this man would have certainly never been arrested that night and may still be out there today killing innocent people. And it continued up and through the work of the people you already identified, like Keith Witherell and Bill Hilbert, who spent nearly 9 hours stroking his ego and telling him what a good person he was in an attempt to get him to eventually admit to what he did, which really without their efforts, I don't know that we would have been able to proceed on a capital case. So without all of their efforts, in my humble opinion, there'd be no way to put us in a position today to ask for what he deserves, and that is a sentence of death.
Did you say you were saying this? Okay. No, Your Honor. Thank you.
Thank you very much. I appreciate the efforts. Everyone's now done their job. It's now my turn to do my job. I have considered as required by statute and law, all the areas The aggravated circumstances are on count 2, Cassandra Crawford, the killing of 2 or more people in the course of conduct, as well as a rape or attempted rape of Cassandra Crawford, who was 14 years old at the age at the time. In Kirkland's own words, that's atrocious and horrible acts, 4 degrees. Count 4, Cassandra Crawford, same aggravating circumstances regarding killing 2 or more people in the course of conduct, as well as the commission of aggravated robbery. Extremely serious, egregious criminal acts by Mr. Kirkland. Count 9, Esme Kenny, killing of 2 or more people in the course of conduct, as well as the rape of 13-year-old Esme Kenny. Again, in his own words, atrocious, horrible acts. I agree. Count 11, Esme Kenny, killing of 2 or more people in the course of conduct, commission of an aggravated robbery. Again, extremely serious, egregious criminal acts. The bottom line is, there are extreme aggravating circumstances by any measure that are to be found to be committed by you, Mr. Kirkland. In my opinion, I'm entitled to this at this point. You have complete disregard for human life, and in your own words, you have no explanation for the acts that you committed. Those aggravating circumstances versus the mitigating factors. The mitigating factors I've explained in detail in my sentencing opinion. I'm not going to go through all of them now. I will say this. Now, considered as required by law, all the mitigating factors specifically stated in the statute, all mitigating factors argued on behalf of Mr. Kirkland, and even possible mitigating factors were considered by the court. Upon review, no one single mitigating factor was given any real measure of value by this court, and taking all mitigation together, the court finds little mitigation at best. The court does not countenance that Mr. Kirkland suffered from brain damage that contributed to his inability to conform to the law. And by conform to the law, I mean not viciously killing other human beings. No childhood abuse, in fact, that occurred, provided any true mitigation, so this court could weigh that factor for Kirkland and surmise and find Kirkland's bad behavior caused him to viciously kill human beings, as opposed to having a lack of conscience and a complete disregard for human life. This court, as it is obligated to do, search for and analyze for mitigation on behalf of you, Mr. Kirkland. I would offer just this. I have found very, very little mitigation in your favor. After weighing the aggravating circumstances against the mitigating factors, the court finds as follows. On count 2, the aggravating circumstances far outweigh beyond a reasonable doubt any and all mitigating factors for Anthony Kirkland. On count 4, the aggravating circumstances far outweigh beyond a reasonable doubt any and all mitigating factors for Anthony Kirkland. On count 9, the aggravating circumstances far outweigh beyond a reasonable doubt any and all mitigating factors for Anthony Kirkland. On count 11, the aggravating circumstances far outweigh beyond a reasonable doubt any and all mitigating factors for Anthony Kirkland. Having made such a finding, the court knows what the law states and knows what the law is. The sentence. We'll go ahead with the sentence. As a person who morally believes in the sanctity of life, that's me. To judge another, to determine if the imposition of the death penalty is appropriate, is not a duty that I take lightly. I believe all those involved in this case feel the same. In this great land of America, we live by the rule of law. The rule of law. Without the rule of law, we have anarchy. And in anarchy, those who are not able to protect themselves become prey for people like you. We need the rule of law. I will say this, and I mean it from the bottom of my heart. I took an oath to follow the law, and I would do that. To do otherwise is morally, legally, philosophically, and theologically wrong. So if we as a people, as believers in the rule of law and justice, are going to have the death penalty imposed on the worst of the worst, then if not you, Anthony Kirkland, who? I find without any cause, without any regret, without any doubt, that in this case, State of Ohio versus Anthony Kirkland, the evidence warrants the following sentence, the law permits the following sentence, and justice demands the following sentence. Count 2 for the aggravated murder with specifications of Cassandra Crawford, the court orders the sentence of death be imposed. On count 4, the aggravated murder with specifications to death of Cassandra Crawford, the court orders the sentence of death be imposed. Count 9, aggravated murder with specifications to the death of Esme Kenny, the court orders the sentence of death be imposed. Count 11, aggravated murder with specifications of Esme Kenny, the court orders the sentence of death be imposed. And I will assess the cost. It makes me sick to my stomach to have you stand here and talk about your money in imprisonment. Now, we're talking about 13 and 14-year-old kids that are killed by you. In compliance with the law, in the Ohio Revised Code, the court orders the following date of execution to be March 9th, 2019, which happens to be 10 years to the date that you took the life of Desmond Kennedy. May your victims now rest in peace. I do have to tell you the rights to appeal. You have the right to appeal. If you're not afford the cost of appeal, you may appeal at no cost to you. If you're not afford the documents necessary for an appeal, such documents will be provided at no cost to you. If you wish to appeal, an attorney will be appointed for you at no cost. I will appoint an attorney no matter what you say. Anything further from counsel?
Your Honor, he does wish to pursue an appeal. An appointment would be appreciated. Thank you.
Anything to say? Deputy?
I have a question, Your Honor, on a comment that you just made. So if
You know what?
yeah.
We're going to get more.